All rise. The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Welcome to this remote session of the North Carolina Court of Appeals. We're happy to be here in Chapel Hill. To my right is Judge Wood. To my left is Judge Griffin. We'll be your panel for the two cases today. We will hear the arguments in the first case. We'll be at ease for about 5 minutes, because I know some of you probably in the back may want to leave for your next class, and we'll reset the litigants. First case is State v. Smathers, and we'll hear from the appellant. We'll keep the time here and alert you when you're getting close to your time.
Yeah, thank you, Your Honor.
Do you want to reserve any time, or you?
Yes, I'd like to reserve 7 minutes rebuttal.
Please proceed.
Good afternoon. May it please the court, I'm Assistant Appellate Defender Wyatt Orsman, and I represent Mr. Smathers, the defendant in this case. Before I begin, I'd like to say thank you to Carolina Law School for inviting us here and hosting us. It's a treat to be back here. At issue here are the reporting requirements in North Carolina's sex offender registration statute. The statute requires offenders to report their online identifiers whenever they initially register with the sheriff, and to update those online identifiers anytime they make a change to an existing one or they get a new one. Online identifiers include things like a person's email address, instant message screen name, user ID, or a chat name. Mr. Smathers was convicted of failing to notify the sheriff of a new user ID associated with a new Snapchat account. As argued at his trial, his conviction violates the First Amendment. The parties agree that intermediate scrutiny is the appropriate standard for judging the reporting requirements' constitutionality. The standard has two prongs. First, the state must show that the restriction on speech advances an important governmental interest unrelated to the suppression of free speech. And second, the state has to prove that the law is narrowly tailored to further that interest, meaning it does not burden substantially more speech than necessary. There are problems under both prongs of that standard, but I'd like to begin by addressing whether the reporting requirements are narrowly tailored.
Is this a facial challenge or an as applied challenge?
It's a facial challenge. So really the only relevant fact here is that he's been convicted under the statute. At least 8 federal courts have addressed the constitutionality of similar reporting requirements from other states, and the courts have almost uniformly struck them down. The common problem was summed up best by the Northern District of Georgia in the White v. Baker case. Reporting requirements designed to protect the public from communication enticing them into illegal sexual activity should consider how and where that communication occurs. How the communication occurs and where it occurs.
Do you concede the first prong of the challenge or the standard that this law promotes the government interest?
I concede that the state has a compelling interest. In this case, I do not concede the point about whether the reporting requirements actually advance that interest.
Well, why would it not advance the state's interest to protect minors from convicted sex offenders by requiring those people to report to the sheriff the entities, the names which they can use to contact these minors, particularly Snapchat, Facebook, all of those social media things, which is, you would concede that that is one of the ways that people make those connections, would you not?
I think
Predominant way that we found that they make those connections.
I think the problem is the state has the burden of proof on that issue. And the state didn't produce any evidence at trial, despite knowing it had the burden of proof. Right? The state under intermediate scrutiny has the burden of proving that any restriction on speech actually works. Right? We know that from the Turner case. The state has the burden of showing that the harm to be remedied is real, and
You would
that
concede that the harm to be remedied is real, correct?
I would concede that the harm to be remedied is real, but I don't concede that the state has presented any evidence showing that the reporting requirements materially and directly accomplish that goal. There's no evidence in the record showing that the reporting requirements actually work. We're left with conjecture, speculation about whether the reporting requirements work, and that's just not sufficient under intermediate scrutiny. Getting back to where I was, focusing on how the communications occur and where they occur is a recurring theme throughout the cases. Reporting requirements that don't take into account the how and the where aren't narrowly tailored, and they don't survive strict scrutiny or intermediate scrutiny, excuse me. And we see this theme crop up in the Packingham case, where the Supreme Court addressed North Carolina's law that categorically banned sex offenders from accessing social media websites.
But this is much more narrow than Packingham, is it not?
How so?
Isn't it more narrow than Packingham? In Packingham, you couldn't be on social media at all. This, you just have to report to the sheriff your social media.
The online identifiers.
Yeah.
Uh,
How is that not much different?
I think they are the same in the sense that this is categorical too, in that they are categorically required to report all their online identifiers. That's categorical. Everything that meets the definition of an online identifier has to be reported.
Well,
But you're not stopping somebody from, or the Jones is not stopping somebody from visiting a website or commenting on a website or whatever medium they're using.
No, they're not. No, they're not prevented from accessing the websites, but their First Amendment rights are chilled, knowing that they have to report any online identifiers when they post, or if they make a new account to report those.
Citizens United versus the FEC, that it may burden the ability to speak, but they do not prevent anyone from speaking. Isn't that the same thing here? It puts a burden on them to be able to speak, but no one's saying they can't. They can still access the online, they can still email, they can still Snapchat, they can do all of that. All they have to do is notify the sheriff of their identifiers.
Yes, absolutely. But that goes to a preceding question, which is whether the reporting requirements burden or chill First Amendment rights. That's right. That's backstream to
You're saying it's
to
not
the issue here.
tailored enough.
Right. That it's not narrowly tailored. Right. Even though their rights are burdened, the analysis moves on to figuring out whether it's narrowly tailored, and the reporting requirements here are not. And I'd like
Is it correct that they have to send these identifiers in, but they're not wholesale published by the sheriff? Is that correct?
well, they don't. It's more burdensome than just sending them in. They have to do it in person, in writing. And anytime they create a new one, they have to do it within 10 days.
But don't they have that same obligation as far as where they live?
Yes.
Yeah.
Yes. And all of that same information though is collected by the state and available to law enforcement agencies and the public. Yeah. Yeah, so the online identifiers in that sense are different than any of the other information that they have to report.
But they're not, the sheriff doesn't necessarily automatically post this outside their office window and say, these are the identifiers for John Smith, the sex offender. They don't do that automatically or anything, once they get this information.
Well, that's one of the problems that arises in this case, because the reporting statute does have provisions that relate to public disclosure. The statute doesn't require the state to automatically post this information, but the state collects and retains this information. And if you look in the legislative statement of purpose, it says that this information can be released to the public or to law enforcement agencies so long as it's rationally related to public protection or law enforcement investigations.
Well, the public has to make a specific inquiry with respect to this particular person to get the information, do they not?
Yes, but that's all they have to do. They don't have to give a reason. They don't have to give a bad reason. They don't have to give a good reason. They don't have to give any reason at all. They can.
Well, the General Assembly gave them a reason, and the offender gave them a reason. They're registered sex offenders.
Yes, but an offender's information could be misused by law enforcement agencies or by the public once it's obtained.
How can a user or an online identifier be misused by law enforcement or by the public?
The White case talks about this extensively. There are quite a few problems without any real constraining principle on like what public protection means or what law investigation means. They can use once an individual has an offender's online identifiers, they can post it on the internet. It's free game to be posted on private watchdog websites. That's misuse. That's not protecting their privacy. I mean, that's a real First Amendment problem. Did I answer your question? I just want to make sure before I move on. Okay, great. In Packingham, where the court addressed the categorical ban on sex offenders using their websites, the state's primary argument was that the ban had to be as broad as written. It had to be categorical to serve the preventative, and this is the court's words, preventative purpose of keeping convicted sex offenders away from vulnerable victims. But the court rejected that argument as unsubstantiated. It held that the state hadn't met its burden of showing that the sweeping law was necessary or legitimate to serve that purpose. In sending our General Assembly back to the drawing board, the court told it exactly what to write. The First Amendment permits the state to enact specific, narrowly tailored laws that prohibit a sex offender from engaging in the conduct that often presages a sexual crime, like conducting a minor. This directive from the court told the General Assembly to focus on the how and the where. How does this conduct occur and where does it occur? And in his concurring opinion, Justice Alito goes into even more detail, saying that the fatal problem for the ban is that its wide sweep precludes access to a large number of websites that are most unlikely to facilitate a sex crime. And this is because much of the communication that occurs on social media sites occur out in the open, reducing the possibility of an offender communicating with a minor in an inappropriate way. And thus, according to Justice Alito, the scope of the ban unnecessarily extended beyond websites that provided essentially no aid to a would-be sex offender. And here, the reporting requirements are, as you've read the briefs, you know that there are two competing readings about the reporting requirements and the definition of an online identifier. The state argues that the term online identifier and its subparts are best read as focusing on private person-to-person communications, the kind of online accounts that offender is most likely to use to recidivate. On the flip side, I read the broad language or the plain language more broadly. I think that the plain language sweeps in accounts linked to internet platforms that an offender could not reasonably use to commit a sex crime. And here, I think context is absolutely critical to understand. On the very same day that the General Assembly enacted the social media ban at issue in Packingham, it enacted the provisions that are being challenged here. The statute defining what an online identifier is, the statute requiring offenders to report them, the statute making it a crime to not report them. But in Packingham, the state argued that the General Assembly intended the social media ban to be as expansive as possible. It had to be categorical to achieve its purpose. But the state's new position is that it's swearing off the approach it took in Packingham. The state's new position is that the General Assembly didn't intend the terms online identifiers to be given that same expansive meaning. According to the state, the term online identifier only covers private interpersonal communications. But why does the state argue that two laws enacted on the exact same day and that cover the exact same subject matter should be given such radically different readings? The answer is simple. Packingham happened, right? We now know after Packingham that the state's argument that the General Assembly intended these two statutes to be read broadly, as it advocated in Packingham, the state knows that argument won't fly under intermediate scrutiny. That is indicative of the General Assembly's intent that the social media ban be read broadly, just as the term online identifier be read broadly. Surely, the General Assembly intended two laws enacted on the same day that cover the same subject matter, offenders using the internet, to be read consistently with one another. So why is the social media ban to be read as expansive, as categorical, but this one should not be? I think understanding this context, this close connection between the social media ban in Packingham and the reporting requirements in this case distinguishes the state court cases that the state relies on in this case. Whatever the legislative intent was behind those statutes in those cases, that was for those state courts to decide. But we now know what our General Assembly's intent was. It was for these statutes to be read as broadly as possible. We know that because that's what the state told the Supreme Court in Packingham. In the plain language of the statute confirms that expansive reading. I mentioned up top that the definition of an online identifier includes things like electronic email address, instant message screen name, user ID, chat names. And some of these have, sub-definitions. But I want to run through some of these and give examples that show that the statutory language is written broadly and is intended to be written broadly. Sure.
Copyright
No,
that
please.
first one, because we are talking about sex offenders. And so there is, the registration program already provides for a sex offender's name and age and address and conviction date and status and physical address that all be public already. I mean, that is already readily available to the public. In this case, the online identifiers are not readily available to the public unless they are specifically requested in writing by someone actually asking for information about this particular sex offender. So why would the registration program itself, under your scenario, not also be considered unconstitutional? It's already been deemed to be constitutional. I mean, the information is public. So why is this any different when it's online identifiers?
Because the First Amendment applies to the internet just like it does anywhere else. I mean, using your online identifiers is expressive activity, affirmatively made by the offender, whereas having to report that information, that's passive. That's not First Amendment speech. But using your online identifier online, sorry, that is speech. So the First Amendment is implicated, and you've got to comply with the First Amendment.
I mean, I know your position is chilling speech, but is anybody compelling anybody to speak with their identifiers on the government side? Is the government making them use these identifiers in the internet forum?
If they want to be citizens of the modern world, yes.
So the government is forcing them to participate with social media, Snapchat, and all the stuff we listed before, Facebook.
No, but this is what Packingham, what Justice Kennedy was talking about in Packingham. The internet is the new modern square, right? To chill someone's speech and like their ability to engage in this meaningful speech, right? It implicates the First Amendment. No, they're not. No, they're not compelled.
Offenders walk into elementary school.
Mm-hmm.
We do.
I'm sorry. I must have misunderstood.
Walk into an elementary school.
No, we do not.
Okay. I mean, is that a forum a traditional forum? I mean, is that a public square, a public education forum? I mean, is that something are you trying to analogize those two? The internet with just everyday life?
No, I'm trying to analogize the internet to pamphleting, to the standing up on your soapbox on a street corner.
So speaking of that, standing up on your soapbox on the street corner is public, and you can identify the person that's doing that. And realistically, what you're containing is these online identifiers shouldn't have to be reported so these people can speak, but they could speak anyway under their name. The issue is whether or not they can speak anonymously, right? Because they're online identifiers identifying who these people are. So this isn't the same as standing up on your soapbox and speaking in the public square, is it?
No, it implicates the right to be able to speak anonymously online. Yeah, absolutely. I'm not sure how much time I have left. I want to be respectful.
You've used 21 minutes and 50 seconds.
Okay. Let me just sum up with just a couple of points that I want to make. The plain language of the statute shows that it was written broadly, that the General Assembly intended these to be extensive. If you look at the definition of an email, it covers not just communications, it covers transmission of information. That covers no reply emails that we get from administrative office of the courts about our retirement. Right? It covers workflow emails. Anytime Amazon tells us our package is shipped, that's triggered by the definition. The other online identifier that I want to mention briefly is the user IDs and chat names. The statute does not define these terms, but the common understanding of these terms shows that they extend to online platforms that an offender could not reasonably use to commit a sex crime. And I've got a great example from my personal life. If you use TurboTax to do your taxes, there's a button you can click to get help from a CPA. You click that button, a dialog box opens up. When that dialog box opens up, it is automatically pre-populated with the user ID you use to enter into to log into your account, and it identifies you to the person on the other end. But as Justice Alito said in Packingham, there's no reasonable way that an offender is going to use the chat function on TurboTax to commit a sex crime against the CPA on the other end. It falls within the term user ID and chat name, but it couldn't possibly be used to commit a sex crime. I'm sure I'm out of time, so I just
Yeah,
want
got 6 minutes left.
Yeah.
So,
So let me briefly conclude, and then I'll say whatever I have for rebuttal. The reporting requirements in this case aren't narrowly tailored to the how and the where. The scope of the reporting requirements go beyond meeting the problem where it is. They cover online identifiers associated with online platforms that a would-be sex offender could not reasonably use to commit a sex crime. But the plain language of the statute and the context around its enactment show that the General Assembly intended an expansive reading. The reporting requirements burden substantially more speech than necessary, and they don't survive intermediate scrutiny. Mr. Smathers' conviction for violating an unconstitutional statute should be reversed. Thank you. And well, unless you have any further questions, I don't want to.
we'll hear from the state.
Good afternoon, and may it please the court. My name is Megan Parsh, and I represent the state. The question before the court today is whether North Carolina's online identifier reporting requirement is facially overbroad. It is not. Like 36 other states, North Carolina requires that sex offenders report their online identifiers as a part of the sex offender registration program. This requirement adapts long-standing sex offender registration requirements, like physical address reporting, to the realities of the digital age. And the online identifier reporting requirement furthers the same compelling interests, protecting the public from the well-recognized risk that sex offenders will recidivate. The facts of this case are a good example. Mr. Smathers, a recidivist sex offender, was convicted for using an unregistered online identifier to send photos of his genitals on Snapchat. Mr. Smathers thus cannot argue that the reporting requirement is unconstitutional as applied to him, and instead brings a facial overbreadth challenge. And that decision comes at a cost. Facial overbreadth challenges are very hard to win, even in the First Amendment context. And Mr. Smathers has fallen far short of showing that the few hypothetical invalid applications that he imagines outweigh the substantial and concededly valid applications of this common sense law. As the text of the statute makes clear.
To address the appellant's argument, the state has not made its burden in this case of showing what you need to show.
Yes, absolutely.
Trial court.
Yes, absolutely. So under intermediate scrutiny, there has to be evidence that the law is narrowly tailored to serve the state's interests. And I take opposing counsel's argument to be about whether or not the law serves the state's interest. And I would direct the court's attention to Turner 1. The first Turner case states that we don't need statistical or empirical evidence. The sound reasoning of the legislature is sufficient here. And we know that several state and federal courts, even those that have invalidated similar laws, have recognized that the risk is real and that these laws serve the state's interest. And so I think that this law actually is well illustrated. The evidentiary burden is well illustrated by the recent case, Free Speech Coalition v. Paxton. There, the Supreme Court recognized that age verification for pornographic websites clearly served the state's interest in preventing minors from accessing that material, and pointed out that this was clear because this was the adaptation of existing traditional age verification mechanisms to the online world, and thus plainly served the state's interest. And so I think it'd be helpful to discuss the applicable standards more broadly, beginning with facial overbreath here, to remind the court that to succeed in a facial overbreath challenge, the challenger bears the burden of demonstrating that the law's allegedly unconstitutional applications outweigh the constitutional applications. And those allegedly invalid applications have to be realistic and not fanciful. So courts have to consider the full breadth of applications of the law and weigh those against each other. And in the absence of a truly lopsided ratio, a law is facially constitutional. And we do agree that intermediate scrutiny applies here to judge the lawful sweep of the statute. Intermediate scrutiny requires that the law be narrowly tailored, but it does not require that the state adapt the least restrictive means necessary to achieve its interest. A law will pass intermediate scrutiny so long as the statute does not burden substantially more speech than necessary, and this is a proportionality test. And this court recognized in its 2013 decision in State v. Packingham that the online identifier reporting requirement is a narrowly tailored law that serves the state's interest without unnecessarily abridging First Amendment freedoms.
George Packingham was reversed. Is that correct?
By the state Supreme Court, but I think this.
Oh, by the U.S. Supreme Court, it was reversed. It not.
Well, this court's decision.
So the rationale under there, I'm not sure is good rationale since that whole line has been reversed by the U.S. Supreme Court.
Well, I think this court's decision in Packingham was ultimately vindicated by the Supreme Court, and we are, of course, this law is very different from Packingham. It is significantly more narrowly tailored, and that's the point I'm trying to make with that reference. This court has looked at this law before and believed it to be narrowly tailored.
Well, so the defendant's position is that the statute is overly broad because it talks about username, it being so very broad. And if you read the statute itself, it seems as though the General Assembly was actually just targeting communication names. But I mean, it makes a good point about username being overbroad. When you log into your banking system, you have to have a username. You log into TurboTax, you have to have a username. Those kinds of usernames obviously are not going to be used to target anybody, other they're just to get into your website, check your credit card balance or your bank account balance. So how do you respond to that statement that username is just overly broad?
Certainly. So I believe that if we look to the text of the statute, we know that there are 4 terms in the statute. 2 of them carry specific definitions. And so electronic mail address and instant message screen name both carry specifically defined definitions in the statute. The statute defines these things as things that facilitate communications between individuals. And user ID and chat or other internet communication names are in a list with those terms in the definition of online identifier. And so the associated words canon tells us that when we have a group of words together in a list, they have to be given associated meanings. We would not assume that the legislature would include general words that read out the specific definitions of the other words in the statute. They have to be read in context with one another and consistently with one another. And this is indeed consistent with the definition of an electronic mail address or an instant message screen name.
So your contention would be the online identifier to get into your bank account is not one that they would need to disclose.
Correct. Our argument would be that that is not an identifier that facilitates private person-to-person communication with the general public.
But
And
isn't that a user ID?
I think
And to accept your version of it, it would have to be ambiguous for us to interpret it the way you would like us to interpret it. Isn't that correct? Under our rules of construction.
so. I believe that the associated words canon is more of a grammatical rule that courts use and any reader uses when they're ascribing meaning to words in a sentence. When you are reading a sentence, you are always considering the context in which the words appear. And so user ID read in a complete vacuum would be broad. But here we have other specific terms in the statute that inform the reader that this word is meant to carry a similar meaning to the specifically defined terms
So
in statute.
banking ID on an as applied challenge, you would concede you'd lose on that?
I think it would be a harder case for the state if an individual had an as-applied challenge where they had reported this information.
But you won't concede that you lose?
Well, I think that reporting that you have a bank account does not necessarily implicate First Amendment speech. I mean, I think
ID.
having that reporting the ID does not implicate or burden your speech in any way. All that tells the sheriff, if you were to report it, is that you have that account. That does not implicate the content, frequency, or use of that account. Banking is not traditionally something that we think of as speech. And so I think it would be a harder case for the state, but that the state would not necessarily lose in that instance. And I think that it's also helpful to remember that the General Assembly has provided us a textually defined purpose of this law, which is relevant to reading the definition of an online identifier as well. And it reinforces our plain text interpretation here. The legislature has explained in the text of the statute that sex offenders pose a high risk of recidivism, and to protect the public is a paramount interest. And they were concerned, as they explained in the text of the statute, that law enforcement officers' efforts to protect communities, conduct investigations, and quickly apprehend offenders who commit sex offenses would be impaired by the lack of information available. So to better serve the state's interests, the legislature determined that collecting information about offenders is necessary to further the government's interest, as long as that information is related to the goals. So if you read this textually defined purpose in context with the statutorily defined terms in the definition, it makes clear that the identifiers are those that facilitate private interpersonal communication. And this is very consistent with how other states have interpreted similar laws. So the Iowa Supreme Court was faced with almost an identical term and definition in State v. Ashburner. And there they rejected the challenger's broad interpretation as inconsistent with the statute's context and the stated purpose. In Iowa, an internet identifier included electronic mail address, instant message, address, or identifier, or any other designation or moniker used for self-identification during internet communication or posting. The challenger argued that that applied broadly to things like blogs, rankings, newspaper accounts, and online shopping accounts, but the Iowa Supreme Court accepted instead the state's plain language, common sense interpretation of the statutory definition as applying to only those accounts used to send message posts and other user-generated communications that implicate the public safety concerns at issue with the sex offender registry. And I think that even if the court were to take Mr. Smathers' interpretation of the statute to be plausible, a textual reading makes clear that the statute would be readily susceptible to a narrowing construction and constitutional avoidance. That would not be rewriting the statute, but rather avoiding the constitutional collision of sorts that Mr. Smathers urges the court to read into an otherwise valid statute. And should the court have any doubts, the applications of the law, even under his implausible interpretation, includes things like, he said, for example, bank accounts, online shopping accounts, healthcare accounts. Many of those things, as I said, do not burden speech. An offender reporting to law enforcement that those accounts exist reveals nothing about their use, and it merely tells law enforcement those accounts exist. And Laird v. Tatum tells us that awareness of this type of government information collecting activity is not enough to chill speech on its
But
own.
didn't the General Assembly, when they wrote the statute, when they put in the phrase, but does not apply to X, Y, and Z, doesn't that cut against your argument that we read the rest of it to cut the rest of these things out that make it overbroad?
I think the General Assembly there was attempting to expressly include kind of detailed personal identifying information, that those things that it listed are listed in a separate list from the list of things that are in fact included. And so that is a list of things that it does not cover, and our 4 terms that we know it does cover are listed together in a group separate from the list of things the law does not cover. And I would also remind the court that this is an overbreadth challenge. So even to the extent that there are perhaps a few edge cases here, they're just edge cases. And to the extent that they materialize, they would be better suited for an as-applied challenge. Because even under Mr. Smathers' implausible interpretation, the statute would constitutionally apply to a substantially disproportionate number of valid applications, things like Instagram, Facebook, Snapchat, Twitter, TikTok, Tumblr, Threads, Reddit, dating apps that facilitate these types of things like Hinge and Bumble, Tinder, things of that nature. any instant messaging platform, any email account. These lawful applications predominate even under Mr. Smathers' interpretation of the statute. And so his hypothetical invalid applications cannot be said to be substantially disproportionate. And these types of identifiers are exactly the ones that Justice Alito said could facilitate the abuse of children in his concurrence in Packingham. He was correctly concerned that a sex offender could create false profiles online that misrepresent things like their age and gender, and could use those profiles to lure minors into engaging in sexual conversations, sending explicit photos, and things of that nature. So it is obvious that the reporting requirement targets a very real harm and advances the state's interest in protecting the public, particularly minors and victims of sexual abuse. And this textual definition of an online identifier makes clear that the reporting requirement is a plainly legitimate legislative choice that adapts existing physical location reporting requirements to the online context. So having discussed the definition and how that definition is narrowly tailored, I would also like to discuss how the disclosure provisions of the law are narrowly tailored. I'm going to begin by discussing disclosure to law enforcement, and then discuss disclosure to the public. So first, this law is a modest disclosure rule. It does not prohibit any speech, and disclosure rules are well accepted as less restrictive alternatives to the actual suppression of speech. Judge Wood, you mentioned Citizens United. This is also something that the Supreme Court has determined in Zouderer. And there, the Supreme Court said that a speaker's rights are adequately protected so long as the disclosure requirement is reasonably related to the state's interest, as it is here. And this is very much unlike the laws at issue in Doe v. Nebraska and Doe v. Marshall, in which sex offenders were required to disclose the content of their speech to law enforcement. And it's very much unlike the case in White v. Baker, where sex offenders were required to report their passwords as well. And so practically, in many of the constitutional applications of the law, disclosure does not even allow law enforcement to examine the content of speech, even if they wanted to. Simply knowing that someone has an email address or an instant message screen name does not allow you to read their communications. And as relevant to this court's overbreadth analysis, disclosure to law enforcement only burdens sex offender speech to the extent that they are using an anonymized identifier. Mr. Smathers was not speaking anonymously online, and he has not put forward evidence alleging that a substantially disproportionate number of sex offenders' online identifiers are anonymized. And we know that this is the only burden that it would place on speech because Laird v. Tatum tells us that the chilling effect does not arise, again, simply from collecting the information. And even to the extent that there is a burden on anonymous speech, information sharing among law enforcement agencies does not impose a burden that is greater than necessary to serve the state's interest in protecting the public, because sharing this information with law enforcement allows them to conduct investigations and quickly apprehend offenders.
But sharing it also allows them and gives them discretion to share it with the public, is it not?
Yeah, so I believe that to the extent that the law permits disclosure to the public, it does so in a narrowly tailored way. So we know that the identifiers are not public record. They are not put on the public-facing registry website, and they can be released if law enforcement believes there's a public safety risk about a particular individual or upon written request by a member of the public.
Law enforcement, is that the sheriff or the police officer? Who's the release authority?
The statute discusses both the county level authority, so the sheriffs that are collecting the information in the county, and the statute also discusses the authority of DPS, who is maintaining the statewide sex offender registry.
So if the sheriff believed that everyone's anonymized ID was that they were all people of risk, he could just, in his discretion, release all of it. Is that your argument? Is what the statute says? That is what the statute says, is it not?
The statute says that law enforcement can release as to a particular individual who poses a public safety risk. And I think the public safety risk, we know from, again, the textually defined purpose of the statute would have to be related to the risks posed by sex offenders and the risks that they will recidivate. So it would have to be a specific risk related to the textual purpose, and it would have to be as to a particular individual.
But Judge Erwin's question, that doesn't limit it to a number of people. Like they could go through that analysis for every single one, right?
Our argument would not fail in that instance. If I think that if a
So
sheriff,
if you say your argument would not fail if the sheriff went through everybody in his database and said, well, I think they're all at risk and I'm going to release all of them, your argument still wouldn't fail?
no, I don't
Okay.
believe so, because narrow tailoring is a proportionality review. And so the court has to consider the extent to which disclosure is necessary to fulfill the state's interest. The state does not have to impose the least restrictive alternative. And so I think that thinking about how the Illinois Supreme Court thought about this issue in People v. Minutes would be useful for the court in thinking about this type of hypothetical. There, the court said that disclosure provisions only identify the locations on the internet where the sex offender has engaged in communication, and which, when that information is released to the public, empowers the public to make informed decisions to avoid the places where sex offenders might be located online. And this is just like with physical address reporting requirements, where someone might check the registry before deciding where to live. And so, as the Illinois court said, public access is necessary for the efficacy of the registration program as a whole. And so it would not be substantially greater than necessary to serve the state's interest, even under that hypothetical. And so I think that the Wisconsin Court of Appeals had a similar analysis in State v. Jackson in terms of allowing the public to request the information. The court there said that because it was not unrestricted, because the statute did say it could be released for public safety purposes, that lack of an unrestricted disclosure meant that the challenger had failed to meet his burden, that it was substantially overbroad. And I would say that public disclosure is precisely targeted to the state's public safety interest. And public disclosure, if it occurs, is, like I said, just like the home address reporting requirement, which is already included in the public-facing registry website alongside things like names, aliases, photographs, identifying markings, all sex offense convictions. And so the reporting requirement is just adapting these conventional things that we think that the public needs to know about sex offenders to protect themselves to the digital age. And I will also say that nothing in the statute requires sex offenders to disclose to the public their identity or status as a sex offender when they speak online. The 10th Circuit drew this very important distinction in Shurtleff, noting that for the purposes of narrow tailoring, there's a meaningful difference between the mandatory disclosure in public of a speaker's identity and the requirement that a speaker provide information to the government that could later be used to trace speech back to its source. And then in conducting the proper overbreath analysis, this court should also remember that, again, disclosure to the public would only burden speech to the extent that speech is made using anonymized identifier. If a sex offender reports an identifier that includes their real name, the disclosure of that to the public would not burden their anonymous speech, because any chilling effect, as the Illinois Supreme Court explained, flows not from the statutory registration and disclosure scheme, but from the fact of their conviction, which is already a matter of public record. And so the application of this rule, even to all sex offenders, is not a greater burden than necessary to serve the state's interest, because the General Assembly has made a reasonable legislative judgment that all sex offenders pose a greater risk of recidivism.
So your argument is that even if the statute had said that would be disclosed just like everything else, then that's not an overburden on speech.
No, that would not
Seems
be
to be the argument you're making.
that would not be overbroad, because again, the court would have to consider the extent to which how many people are using anonymized identifiers. And here, the challenger has to show that a substantially disproportionate number of applications would be unconstitutional. We would argue that it would pass intermediate scrutiny because the public access is necessary, and intermediate scrutiny is a proportionality review. And so we wouldn't think that disclosure would, in any of those instances, would even violate intermediate scrutiny. But even if the court believed that it would have to be the fact that a substantially disproportionate number of the identifiers were anonymized to even potentially raise an overbreath issue. And the burden is on the challenger to put forward evidence that it would be substantially disproportionate. And we have no evidence from the challenger here, that a substantially disproportionate number of individuals use anonymized identifiers. And I think what's important to remember here is that when courts are applying intermediate scrutiny, they're asking whether or not the state's purpose here in protecting the public would be served less effectively absent the application of the reporting requirement. And so I think that also helps the court think about that application. The state's interest would be served less effectively absent the existence of the registration reporting requirement. And the Supreme Court has explained in McCullen v. Coakley that states can demonstrate narrow tailoring by showing that the state considered different methods in other jurisdictions that have been found to be effective. And the state has made such a narrow tailoring showing here. As we discussed in our brief, 36 other states have enacted similar identifier reporting requirements, and every state court to consider the constitutionalities
You're required to make that showing to us, or you're required to make that to the trial court?
I think this is just demonstrative evidence for the court in our explanation here. I think that
Well, that argument was not presented to the trial court, though, was it?
and I don't believe it needs to be. I believe that Turner 1 and Turner 2, as well as subsequent decisions in Free Speech Coalition v. Paxson and TikTok v. Garland, plainly contemplate that where the legislature's reasoning is sound, that is sufficient evidence. And we know that at the trial court, the state presented evidence of the state's reasoning for enacting this law. And I think, as I explained, this is really just like Paxton. The state's reasoning is sound here. It is obvious that requiring the reporting of this information would serve the state's investigative and public safety interests. And that's exactly what the state explained in its response to the motion to dismiss. And during the motion to dismiss hearing, the state explained the interest here was investigative and public safety in nature. And so presenting that sound reasoning of the legislature is all that is required of the state.
Well, how do you respond to the argument? Well, this was put in place the same time that Packingham was. And in Packingham, the states argued we were trying to go as broad as we want to. And here, past the same day, we're trying to be really narrow. How do you respond to that?
Well, I think, quite frankly, they're two completely different statutes. And so what is relevant to
But
determining...
that's passed as a part of a package, were they not? And we all know that.
I think that's most likely correct, but what is relevant to determining the scope of the application of the online identifier reporting requirement is the words in that definition. And so we know that the words in the definition were given specific technical meaning. And so to read those meanings out of the definition of an online identifier would really be to divorce the whole definition from the context that the General Assembly gave us about these definitions. And as I said here, this really is a matter of common sense. Courts in Illinois, Indiana, Iowa, Texas, and Wisconsin have all considered and rejected First Amendment challenges to their state's identifier reporting and disclosure requirements. And Utah's law was also upheld in federal court. We know that this is an investigative tool to law enforcement so that they can more effectively apprehend individuals who endanger the public and abuse children online. The Supreme Court has made clear that empirical evidence is not necessary where sound reasoning like this exists. And Mr. Smathers offers no basis for concluding that the state's determination is not at least a reasonable inference based on the evidence. And that is as the Supreme Court has described the evidentiary burden in TikTok v. Garland just last year. And the facts of this case, I think, perfectly demonstrate the legislature's sound reasoning. Mr. Smathers is a recidivist sex offender. The Superior Court judge characterized his record as one of the only ones they had seen containing only sex offenses, and he used an unreported identifier to send sexual images of himself online. During his sentencing, the Superior Court observed that Mr. Smathers posed the exact type of public safety threat the law is concerned about because he continued to reoffend and did so online even after multiple prior periods of incarceration. The
You have
reporting...
about 2 minutes.
Thank you. The reporting requirement, as described by the Superior Court, gave law enforcement a vital tool to make it harder for offenders like Mr. Smathers to meet potential victims and apprehend them before their conduct escalates. This is, again, demonstrative evidence of the law's narrow tailoring. And now that the internet has become ubiquitous, the state's important interest in protecting the public, and particularly children, and other victims from abuse must be adapted to the online world. Justice Alito observed this in his concurrence in Packingham. He explained that the internet is different from the physical world in important ways as it relates to monitoring sex offenders. It is much harder for parents to monitor where their children are and who they interact with online. And if a sex offender is seen approaching children or in a place frequented by children, their conduct can be observed in person, but that's not the case online. Thank you. The internet allows for an unprecedented degree of anonymity, which also easily permits a sex offender to assume a false identity and lure abused children. In conclusion, North Carolina's online identifier reporting requirement is not facially overbroad. Mr. Smathers asked this court to throw out too much of the good based on a speculative shot at the bad, and the state therefore asks that this court affirm the Superior Court.
Thank you for your argument. You have 5 minutes left.
Thank you, Your Honor.
I guess on do facts, the underlying facts in this case necessarily defeat your facial challenge?
No, it's a facial challenge. The underlying facts of his case are irrelevant. I mean, other than his conviction.
Underlying facts. I mean, it was a Snapchat communication of sexual nature.
Yes. Yeah, that was established at trial. The few points I want to circle back to first is the state's reading of Paxton and about the burden of proof. The state argues that it wasn't required to present any evidence and that it can rely on the General Assembly's considered decision that the reporting requirements will achieve its intended purpose. But I think you got to read Paxton in context, because there at issue was the Texas law of requiring people to provide proof of age before they could access pornography online. But the problem, or the context that I want to bring out, is under the First Amendment, adults have a right to view porn. Children don't. So that was established by Ginsburg. And in Ginsburg, it had already been thoroughly litigated about whether the harm to children caused by pornography was real and whether a proof of age requirement would accomplish that purpose. That's exactly right. There's no reason in Paxton to relitigate those factual issues because they had been decided 50 years ago in Ginsburg. That's what the court in Paxton meant when it said that the Texas law was just, how did they say it? Has just simply adapted Ginsburg traditional proof of age requirement to the digital age. Everything had been established by Ginsburg. We were just updating it to the digital age. The second point I want to touch on is something that I think Judge Airwood mentioned, is what's excluded from the definition of an online identifier, because that's quite telling. One of the things that's excluded is a PIN number. Excuse me, just a PIN. Where do you use your PIN? Banks, at financial institutions. But if, as the state claims, PIN numbers were never meant to be included in the online the definition of an online identifier, because you can't commit a sex crime by online banking or using an ATM, then why is a PIN excluded? Right? Why would the General Assembly exclude something from the definition that was never covered by that definition in the first place? Because the definition covers banks. And then I want to touch on the argument, or the question you asked, Justice Airwood, about textual ambiguity in order to get to the state's reasonableness reading of the statute. We know from the plain language that in order to adopt the state's argument,
1 minute.
this court's going to have to delete the words transmission of information from the definition of email. It's going to have to impose a definition on the term user ID and chat name that's inconsistent with our common usage, and it's going to have to ignore the fact that pins were excluded from the definition. I think that's about all I have time to say. So thank you very much for having us. I greatly appreciate your time. Thank you.
Thank you. Thanks for counsel for your excellent arguments.